the moderation role to my new friend, Justin Brookman, who is the director on the Project on Consumer Privacy at the Center for Democracy and Technology. I'll read his bio in full, and he will introduce the panelists. All of their bios are actually within your packet. But Justin is the director for CDT's Project on Consumer Privacy. Prior to joining CDT in January 2010, he was the chief of the Internet Bureau of the New York Attorney General's office. Under his leadership, the Internet Bureau was one of the most active and aggressive law enforcement groups working on Internet issues, and Mr. Brookman brought several groundbreaking cases to protect the rights of online consumers. Mr. Brookman previously worked as a litigation associate for 6 years at a law firm in New York and in Washington's offices. He received his JD from New York University School of Law and his BA in Government and Foreign Affairs from the University of Virginia. Please help me in welcoming our moderator for this first panel, Justin Brookman.
Thank you. Thank you very much. So I'm going to start out a little bit just by framing the privacy debate, give a little bit of the context of what we're talking about here and why we're concerned about the issue. So from my perspective, privacy has always been a pretty core, fundamental American value. We're a very individualistic nation. We don't want people sitting over our shoulders, snooping on what we're doing. Oliver Wendell Holmes kind of famously characterized privacy as the right to be left alone. And I think that's still the way a lot of us think about it today. We never had a set of robust rules for how information needed to be treated until it started in around the 1960s when the data broker industry emerged, which is like kind of the first wave of companies who are analyzing and correlating stuff that people did across from different stores or businesses. And so in the 70s, the Nixon administration put forward what are called the Fair Information Practice Principles, which kind of tried to lay out basically how companies and governments and anyone should be treating consumer data, basically saying, tell people what you're doing with their information, give them some control over who it's given to. Don't take any more information than you need. Get rid of the old information. If you're selling records and reports on people, try to make them accurate. And so, the United States has passed a few pretty narrow, specific laws trying to incorporate those principles over time. But for the most part, there's no legislated requirements for companies who hold consumer data. But now, those ideas have actually been exported around the world. So most of the rest of the developed world has actually passed laws requiring companies to treat data this way. So Europe has a data protection directive. Latin American countries have data protection requirements. Europe, Asia, Latin America have rules. We're still, I think, the only developed nation without a core comprehensive privacy protection framework. And I think that's probably for a couple reasons. One, the United States is always a little bit more skeptical of regulation, let businesses do their own thing, they'll figure it out. And two, we have more of a free speech background here in the United States. So if free speech has been a core American value, probably more than the rest of the world. So there's ideas about people, we don't want to put rules around what people can say about people. But then the internet age comes up, and in the 90s, people would start to get concerned about behavioral advertising. So when I go to one website like New York Times, it's not just New York Times I'm visiting, I'm also visiting DoubleClick and a bunch of ad networks who might drop cookies in my computer and watch what I'm doing, not just on the New York Times, but on other sites as well. And so in the 90s, this was kind of starting to be a legislative issue. There were bills put forward in Congress. FTC was really interested. And then 9/11 happens. Privacy is no longer the important thing. Security is the buzzword for everybody. So privacy kind of goes away for a while. And then in the last few years, probably starting in the second half of the Bush administration, you start to see privacy become a really big deal again. Certainly the FTC under Chairman Majoris and Kovacic, and now under Chairman Leibowitz really got interested because they heard a lot of consumers starting to be concerned, what's happening to my information online? I don't really have control over it. And now when I go to a mainstream website publisher, it's not just one or two tracking cookies that might be put on my computer, it can be hundreds. And so the Wall Street Journal has done some really strong reporting on this issue, and other news organizations as well, kind of showing just how promiscuous information sharing is these days. And so, and then you think about mobile devices, and it's not just what I'm doing on any given app. The mobile applications have access not just to my browsing history, but to all the information on my phone, my contacts and my location information. And sometimes they do a pretty good job of telling me what's going on, and sometimes they might not. And so there's, I think, very legitimate questions about, people's rights are, and whether there are people are being scared to adopt new and emerging services because of these privacy concerns. And I think people have recognized that the framework we have today really isn't doing quite a good enough job. And the FTC has been pretty clear this is a problem. The Department of Commerce has been pretty clear this is a problem. Members of the legislature of Congress on both sides of the House said this is a problem. The European Commission said this is a problem. They have a law in place to try to protect consumer data, but they're not doing a great job either. So we really need to think about how to put forward a framework that protects consumers' legitimate interests, but still encourages like the dynamic and amazing innovation we've seen in technology and the internet and mobile devices the last few years. So we have on this panel mostly industry companies, some of the biggest companies that touch and use consumer data, and they're going to talk about some of the things they do as international companies who are subject to varying competing jurisdictions, who have consumer-facing sides. So when they mistreat consumer data, they get hauled before Congress or put in the front page of the Wall Street Journal. They're going to talk about what they do to help protect consumer data and when they see this policy debate going. And we also have Deborah Berlin from the Project to Get Older Adults Online from the advocacy side. And then we'll hear from you guys and get questions from you guys about what they should be doing and what's going to happen in the next couple of years. So we're going to start down there at the end. Link, you're up first. And so why don't you give your opening spiel.
Okay. Thank you. Link Honing with Verizon. Good to see you here this morning. I don't think we need to start off with a big discussion about how much the internet has transformed a lot of what we do in our daily lives. Clearly, it has had a major impact. There's so much that can be done online today that obviously people use it more and more for many parts of their lives. And as powerful and exciting as these developments are, they also highlight privacy concerns. One of the reasons that's so is that mobile devices actually take connectivity to a higher level in some ways. The devices that you have today are really computers. They are carried with you, so they're much more personal to you. You're reachable wherever you are. Not the same as a landline connection, which can be shared in the home in many cases by many people. And in many cases, they're not as customized and as individual as mobile devices tend to be. So they tend to take internet connectivity to a new level. And increasingly, especially with respect to adoption of broadband wireless, as Nicole and I have exchanged a lot of data about this in the past, and her research shows this, is an important way that African Americans connect, in some cases more than other parts of society. So for all these reasons, obviously privacy in the mobile space is an important part of the whole privacy discussion. We believe to harness the full power of the internet, we need to establish norms and ground rules that promote innovative uses of information while respecting consumers' legitimate privacy interests. And as we go about establishing these privacy guidelines, we also need to be careful to avoid creating an overly complicated regulatory environment. The U.S. has a range of data privacy laws that apply to individual sectors of the economy. That's how we've tended to do privacy. An issue pops up in a certain sector, gets a lot of attention, and then often we do prescribe or set rules that apply to that particular sector. An overarching set of privacy principles on which consumers and businesses can rely could create a stronger foundation, in our view, for consumer trust in the internet by providing this broadly applicable framework. As Nicole said, I do think trust is an important part of making sure the internet does continue to grow, become more valuable for consumers. As a result, Verizon believes that it's time to look closely at the idea of establishing a privacy policy framework that covers all players in the online space, creating a level playing field that will spur competition and innovation, and provide consumers with more certainty and reduce confusion about accountability. And we believe that Kerry-McCain legislation offers a good starting point for creating such a framework. We actually commented very positively about the bill when it was introduced. Obviously, there's going to be a lot of work to be done on the legislation, but we think it's a good starting point. The legislation would set forth basic baseline consumer data privacy protections that are enforceable at law and are based on a comprehensive set of fair information practice principles, or FIPS. Comprehensive FIPS, a collection of agreed-upon principles for the handling of consumer information, would provide clear privacy protections for personal data in commercial contexts that are not covered by existing federal privacy laws or otherwise require additional protection. The bill also provides a single expert agency, the Federal Trade Commission, with the authority to enforce any baseline protections. The agency would not pursue its work with traditional rulemaking, but instead would use the consumer enforcement and investigation tools that have proven to be an effective model to both protect consumers and allow for the growth of innovation. The legislation also creates a framework that provides incentives for the development of codes of conduct, as well as continued innovation around privacy protections. It authorizes the use of safe harbors for companies that implement codes of conduct that are consistent with the baseline protections. And this approach is designed to be flexible, to keep its requirements well tailored, and to provide a basis for greater interoperability with other countries' privacy laws. The use of baseline principles, safe harbors, and investigative enforcement procedures would, in our view, establish an approach that is broad and flexible enough to allow consumer privacy protection and business practices to adapt as new technologies and services emerge. This type of flexible but accountable approach will help motivate firms to produce an industry code of conduct as a way to construe and clarify the statutory scheme. Thus, a baseline privacy framework and incentives for industry to develop codes for conduct can go hand in hand. A baseline law also holds the promise of making our consumer data privacy more interoperable with international frameworks, which we think is important too in the global context. FIPS is a common language used by many governments worldwide, so use of similar terminology will enhance opportunities for agreement and practical approaches to data policy. Establishing baseline commercial data privacy principles will contribute to the further harmonization of the global economic e-commerce scheme, especially for countries allied with the EU, the OECD, and the APEC. Improving global interoperability could benefit companies by removing barriers to seamless cross-border services that compliance with differing privacy regimes can impose, especially in the cloud context, which is an important part of most companies' growing online businesses. This process would allow stakeholders to develop codes of conduct that address privacy issues in emerging technologies and business practices without the need for additional legislation. In this framework, appropriate incentives such as a safe harbor will spur business to develop and adopt effective codes of conduct, and compliance with an approved code of conduct could be deemed compliance with a statutory FIPS. We think it's time to consider the adoption of a privacy framework like this. The legislative framework we adopt should not add duplicative or overly burdensome regulatory requirements to businesses that are already adhering to the principles in the baseline consumer data privacy legislation. Legislation should be technology neutral so that it allows firms flexibility in deciding how to comply with its requirements and encourages business models that are consistent with baseline principles but use personal data in ways that we have not yet contemplated but could add real value to the consumer. I think it's important to stress that. We do think that a new privacy framework is a useful construct, but we also believe the ability to experiment, try new business models to provide new value to consumers is also critical. It's what made the innovation of the Internet so important to our economy. And domestic privacy legislation should provide a basis for greater transnational cooperation on consumer privacy enforcement issues, as well as more streamlined cross-border data flows and reduced compliance burdens. So we believe with the right privacy framework, it is possible to create an environment that gives consumers more certainty, choices, and protection, while at the same time encouraging innovation and new value for consumers. These are all hallmarks of an innovative industry, and that's what we believe the mobile industry is. Thanks very much.
Thank you, Link. And now Eric Wenger from Microsoft.
Thank you. We want to thank the Joint Center for hosting this important and timely event. We think that you're asking the right questions and you're asking them at the right time. Trust is key in any business where consumers are allowing you to handle very personal information, and few things are more personal than who you're communicating with, what you're saying, and where you're located. From our perspective, it's important to have privacy by design, transparency, choice, and security. Privacy by design is a significant consideration during the design, development, and deployment of our products and services, not a function that's bolted on after the fact. In terms of transparency, we work hard to provide understandable information about whether and how we will use your data. We tell you how we collect, what information we're collecting and how we're going to use it. Sometimes it's to provide a product or service, to improve the service, or to prevent fraud and the like. But we don't use your data in ways that we haven't explained in our privacy notice. In terms of choice, we want to make sure that we give you meaningful opportunities to decide whether and how your information will be used by Microsoft. And then security is an important component as well. We are stewards of the data that we handle in the course of interacting with our customers and users, and we're responsible for ensuring that we have taken reasonable protections to guard against loss, theft, or misuse. Turning to the specific topic here today, we're seeing unprecedented adoption rates for Internet-enabled smartphones. Smartphones were mostly used as ancillary devices for really sophisticated high-end broadband users. But prices are dropping to the point now where we're seeing affordable options for average cell phone users. And there are even smartphones that you're seeing in the prepaid space. So it's increasingly possible to buy data plans with lower minimum amounts or metered use of service in the range of 1 to 2 gigabytes per month instead of having to buy a plan that has an unlimited use. And so this means that there's increasing access to these smartphones and broadband data plans to new populations, persons of color, seniors, other minorities, low-income families. And for these populations, this may be their first exposure to ubiquitous broadband. This may require us to think differently about how we engineer products and services to offer users real transparency and information and meaningful choices. So, some of the things that we have developed have been based on assumptions from customers who have used computers that were connected to broadband, and now, and so they may come to smaller screens and the interfaces that we have on phones with their experiences that they have from computers that are connected to broadband. And that may be different than people who are coming to use broadband for the first time on these smaller phones, smaller screens. So it may require us to think differently about how we engineer these products and services. And so the interfaces are vastly different when you compare them to computers. The screens are smaller, the text is smaller, the ways we interact with the devices is different as well. And so this presents us with new challenges and opportunities. Because the interfaces are different, they present us with ways of interacting with customers that we haven't had before. And in terms of Microsoft, we have our Windows phones and Kinect, which is an add-on to the Xbox, which allow us to develop new ways of interacting with our customers and users. And so we're enabling them to interact with these devices using touch, voice, gesture, and these new ways of interacting with computers are really based on the idea that over time we will develop computers that are actually able to understand what people want to do instead of having to make people have to figure out what computers want to do. And some of these new innovations and the results of the research are being fed back into the operating systems as well. If you've seen any of the previews of Windows 8, you'll see that some of the interfaces that we've developed on the phone look like they're being rolled back into the operating system for the computers. And so these new ways of communicating with computers and devices we think will be more natural and intuitive to users. But it's an ongoing process where we test new interfaces, we see what works, and we have to make adjustments. And some of the assumptions that we've made based on experiences with people who have long-term experience with computers may prove to be applicable here, or they may not. And so that's going to be a challenge for us. In terms of government policies, we want to make sure that we promote robust privacy protections, that we enable a wide range of innovative products and services, and we provide lasting protection against technology changes, because we have to understand that the technology is going to continue to evolve, and we have to allow for that. So that means that the policies that the government develops should be sufficiently flexible to allow companies to tailor the use of information that they have to the relationship that they have with particular customers. We have to make sure that there's certainty so that companies know whether or not particular practices are going to be permitted. And we have to simplify data flows to allow for global commerce. And finally, we have to make sure that the policies that are being adopted are technology neutral so that they avoid preferences for particular solutions. I would note that as Link pointed out, that Microsoft has been a long-term supporter of the idea of comprehensive federal legislation in the area of privacy, and that Microsoft similarly supports the privacy bill that was introduced by Senators Kerry and McCain. In our view, the bill is important because it preempts state law and does not include a private right of action. It allows for a safe harbor for robust industry self-regulatory programs like online advertising, and recognizes that there are legitimate uses for data in operational purposes like analytics and providing personalized services. So that's basically the message I wanted to give. I'm happy to answer any questions.
Thanks, Eric. I feel like I shared the bios up here, so I'm not doing a very good job of explaining how awesome you people are. But Bob Quinn from AT&T.
Hi, thanks for having me here today. I've been AT&T's Chief Privacy Officer now for almost a year. We're getting pretty close to it. My predecessor, Dorothy Atwood, was the first chief privacy officer that we had at AT&T. And when she took that job over, and she had that job for about 2 years before she left us, we had 17 different privacy policies that were drafted by lawyers that read like contracts, very, very difficult to understand. And they were drafted by people at our company who had the incentive to protect the company against any potential liability. And I think Dorothy did a tremendous job of taking those 17 policies, disparate policies for different services in different operating companies, and condensing them into one single policy that we love our lawyers, but we tried to write it in actual plain language so that we could get away from very difficult to understand policies. And when we introduced our new privacy policy, our new unified privacy policy, we actually put it out for a 45-day public preview. We took comments on it from the public, and we actually made some changes based on the comments that we received in areas that people identified that they didn't understand. We thought it was perfectly clear, but we're looking at it from a different end of the prism than the consumer's looking at it. We also put up on our website videos that are designed to be kind of very helpful, click on, so that folks can actually get a real person trying to explain to them exactly what it is that we collect and how our privacy policy operates. Our goal is to give the customers transparent notice about our collection and use of their personal information. Now, we've talked, both Link and Eric have talked about wireless, and obviously at our company we believe that the whole world is going wireless much faster than I think anyone had anticipated before. And with respect to with mobile broadband service, as this audience probably knows, there's a lot of data that suggests that minority and low-income communities use wireless service as their preferred mode of broadband access. I think the reasons for that are we have subsidized handsets that make entry into the broadband world more affordable, for example, than on the wireline side. We have tiered data plans that make entry level very inexpensive to the consumer. But we have additional challenges when we get there. The additional challenges include when we put a mobile handset in somebody's hand, as I think Eric pointed out, they're just computers, but you have a much smaller screen size. So the challenge is making that notice real to the consumer. Even our privacy policy, which encompasses about 8 or 9 pages, is going to be very difficult to read on a small handset. So I think that's one of the big challenges that we have to overcome. And because the mobile device that we're giving to customers is in essence a computer, it has the ability to track location and other information about the customer's use of broadband service that poses challenges to the industry. Now, in the old days, being a telecommunications carrier, we have always had a privacy framework on the telecommunications side of the house. The legacy AT&T was subject to the CP&I rules that are established in statute and governed by the FCC as a part of their authority over common carriage regulation. So in the wireline space, in the traditional world, who you called, where you were calling from, that was all subject to the CP&I rules that governed and restricted the ability of the underlying carrier to utilize that information or to share that information. The difference is when we moved to the broadband world, in the old days all the communication was located at the center. It was located within the network. We were the entity that had all of that information, and it was easy to say, okay, as the telephone service provider, we're going to restrict your ability to share that information, and therefore it's a one-stop shop in order to control that information. In the broadband world, as we've moved the intelligence to the edge of the network, and people are providing what are called information services over broadband pipes, those same traditional rules that apply to telephone companies no longer apply. And that presents a huge challenge. Even the most sophisticated users of mobile internet or broadband may not realize all the different players who could be involved, for example, in collecting location data on where the particular phone is at a particular point in time. For example, an AT&T subscriber could download an application for an app store, an Android store, or the Apple App Store, or they could download an application directly off of the web, off of a web page off of the web. Any of those applications could have the ability to derive location information from the handset. They may obtain it by partnering with another location service provider, which could be collecting the Wi-Fi signals, for example, that your handset can see, and triangulating data based off of those Wi-Fi signals as to where you're at any particular point in time. They could be getting the GPS data off of your telephone handset. The phone itself may be collecting cell ID information so that it can communicate back to the cell phone to tell it what towers it's talking to, and that may be able to derive location information off of that data. None of that information is coming directly from the telephone company, as it were. All of that information can provide some sense of where you are at any particular point in time. And we know that that's sensitive information on the one hand. On the other hand, there's a great value to that. How many people have pulled out their Google Apps or their Bing Maps application on their phone to say, hey, my throat's a little scratchy today, where's the nearest Walgreens or the nearest CVS? And it will identify for you exactly where that CVS is so you can go right to it. There are all kinds of coupon companies that are coming out where if you're walking past a store, they can shoot you a coupon that says, hey, you're at this store right now, here's some deals that may save you some money. So there's value to the location information that's out there, and I think the important challenge that we have as an industry is going to be to make sure that the customers, in our view, have consented to the use of location information and other information that's being used in order for them to kind of get the benefit of the bargain, if you will. We have tried to design all of our services at AT&T incorporating privacy at the outset. We did have to backdoor some things because before we had a privacy policy in place or before we had a chief privacy officer, we didn't always design services with privacy in mind. We designed them with the CP&I rules in mind. As we've evolved, we're now getting in on the front end of all of the broadband services that we offer to try to incorporate some of these privacy aspects into the offerings that we make to consumers. But the days of the telephone company being able to solve the problem with a one-stop shop like we had in the old CP&I days of Title II are over. We can't do this on our own, and we have to work collaboratively with other parts of the broadband, particularly the mobile broadband ecosystem, in order to advance the ball, if you will, on some of these privacy issues. To that end, we have worked with CTIA, which is the wireless association that includes both wireless companies as well as handset manufacturers, on a best practices and guidelines for location-based services. These guidelines are based on two principles: transparent notice to the consumer and consent from the user to utilize their location information. We've also been involved with the Future of Privacy Forum with a broader group that includes not only some of the same players that are there in the CTIA world, but Google and Apple and I believe Microsoft have been involved in those discussions to try and create guidelines that are, I think, at the end, designed to if we can ever get there, kind of create a good housekeeping seal of approval, if you will, so that people know that certain apps are going to act in a certain way, and we're going to have the ability, obviously, to enforce that. But we're working collaboratively with the industry because I believe that we all understand that no individual piece part of this industry is going to be able to solve the situation on its own. We're going to need the cooperation of the handset manufacturers, the operating system manufacturers, the search engines, and as well as the network providers in order to create robust tools so that the end user at the end of the day has the actual and real notice of how their information is being used and can participate to make the choices about how that information is going to be used. And that's what I had today. Thanks.
Thanks. Let me hop into the question first for the panel before I get to you, Ross, to just give you a little bit of context of what people were talking about here. So one of the questions that we heard in the congressional hearings on privacy a lot recently is, what's the harm? Right? What are people concerned about? And so can we maybe give people a little bit of the context about how people's information really is being used online? Is it just, in the mobile devices, is it just for advertising? Does it result in people getting different prices or different quality of offers? Does it go to insurance companies? I mean, what's happening? What are we concerned about here? I'm going to cold call on somebody if they don't answer it. All right, Ross, you haven't talked yet, so I'm going to go to you.
So I don't think that I think so. Some people will come up and say, no, there is no harm, and but I don't think you'd get that answer out of anyone who's up here today. I think there are definite potentials for harm. I don't think that the harm is necessarily advertising, getting more specific advertising. I like cars, they give me ads about cars, fine. So personally, that's not something that bothers me. But when you start getting into some of the other issues that you mentioned, such as pricing distinguishing between people based on what you know about them, that's concerning. And then there's a whole host of potential harms that come from issues regarding what we might call sensitive information, and then that's a category that, depending upon who you talk to, can get a little fuzzy around the edges. But things like health information or financial information, when you start edging into territory like that, I think there's actually definite possibilities for harm. And when you start talking about youth, and when you start talking about cases like a gay kid and suddenly that's known about and that comes back to bite the kid somehow, I think there's definite possibility for harm there too.
And are there industry rules around this? I mean, if I'm walking to Walgreens and I say I have a scratchy throat to my Walgreens app, I mean, what can happen with that? I mean, will that be sold to my insurance company? Will I get offers for cough medicine, which I might like, or I might want some control about it? I mean, what's actually happening now? Will I get different prices if I use the Neiman Marcus app instead of the Walmart app? I mean, just as a consumer trying to figure out what happens and what's going on today.
Well, I think the best practice is that there's the problem with this space is that there's good guys and bad guys. I mean, there are companies out there who have decent privacy policies when it comes to their advertising networks, and actually follow them. And I think that the good actors would say that kind of information is, they don't collect it, they don't advertise on it, they don't monetize in any way. That sort of sensitive, like health or religious or sexual preference, that kind of stuff they try not to track, and they don't use. So, but I mean, then there are bad actors out there who, what they do with it is kind of less known.
Justin, part of it is that you're also looking at areas where, in some cases, these kinds of services haven't really developed that much yet. A lot of the benefits you already see with the kinds of data that companies have today about consumers is convenience. For example, when you go to a website, it knows who you are already, and you can store your information on there. And if you want to order something, you don't have to worry about putting your credit card in. Those are all examples that have been out there for a while, and generally companies have done a pretty good job of protecting that information. These new models, I think we're going to take some time to figure out exactly how to make them work in a way that gives the consumer enough transparency they understand what the companies want to do with the information and what kind of benefits the consumer would get, so they can make decisions about it. The other thing that I think you need to keep in mind is there's really two, and the way we look at it, two kind of levels of a matrix here. One is the sensitivity of the data involved, and the other is the use to which it's being put. So there's some, if you think about how consumers look at this, I think most of them are pretty savvy about a lot of what companies do with data. For example, when they sign up for a service and they have to pay for it, they know there's a level of information they have to provide that's pretty detailed, and they expect that. What they don't expect the company to do is then turn around and use that information in a way they weren't expecting it to. For example, selling it to some listserv or something. So I think part of it is make sure we understand what the consumer expectations are when they're getting notified about the information, and make sure we follow through on that so that they aren't surprised about how the information is used going forward.
Hey, Ross, please, CCIA.
So good morning. I just want to say thanks first to the Joint Center for kind of getting us all together. It's great to kind of talk about this subject with a interesting new lens on it that maybe some of us up here haven't haven't had a chance to talk about before. So really appreciate that. So I'm Rush Ullman. I'm from the Computer and Communications Industry Association. And for those of you who don't know us, we're an industry group made up of information service providers. So lots of folks that you guys know: Google, Facebook, Microsoft, Yahoo, and so forth. So folks that do cool things online is essentially the short of it. First of all, pretty much all of our members are dedicated to privacy, engage in privacy by design, have hopefully, we hope, easy to understand and easy to comprehend privacy policies and follow them for the most part. So we are all kind of, privacy is one of the big things that we all do. So kind of keying off what has already been said a lot, whenever industry talks about privacy, the word trust kind of is the big key. So it's fundamental for the expansion of the services that we provide, and if we don't have it, nobody's going to use the service, and that's been kind of our mantra for going back a long time now. So especially when we're talking now about kind of disadvantaged groups and racial minorities or the poor, that sort of trust is actually even more important. Folks who are unfamiliar with the internet, unfamiliar with this kind of implied exchange of kind of free services, but we're going to serve ads to you and so forth. People who don't know that that's going on are going to be absolutely surprised and turned off by when they do discover kind of what's going on. So that kind of educating in that space, I think, is really fundamental. We think that legislation is definitely one way to kind of approach this problem, but we do want to be careful not to kind of throw the baby out with the bathwater and not to be too restrictive on the innovation that has led to the great services that we see today. And we think that folks in Congress, the legislators who are putting together the bills that we are seeing today, they know this, and that they're doing their level best to kind of strike that balance and reach a good a bill at the end of the day. We haven't endorsed any legislation, but we're definitely watching the process closely, and we're working with legislators to pass a law that's flexible enough to permit kind of innovation and competition on the issue of privacy, and to promote and still allow innovation in business models that do new and interesting things on the internet. We also are looking to make sure that any legislation that does pass is broad enough to encompass everybody that collects information, and particularly not just the online space and not just information providers. So one of the entities in the U.S. that actually collects the most data about people is actually supermarkets. Every time you scan one of those preferred member whatever card, they know who you are, they know your address, they know everything about you, and they know everything that you've ever bought. So making sure that we don't kind of carve out certain areas where the FIPS that we talked about earlier, transparency and choice and accountability, all of that should apply to across the board. One thing that we kind of haven't mentioned yet, but I know Justin was going to make us talk about it if we didn't talk about it, was do not track, and I think in that area we're a little more hesitant. We are definitely keeping our eye on it. We think it's has potential to be useful to the users. I think one of our biggest concerns is actually a problem of definition. I know actually Justin and his team at CDT put together a paper and then revised it again, kind of trying to define this scope of this issue. And I think 10 plus pages, is that what it was? 13 pages. So 13 pages trying to define what tracking is, and I know that one of the bills in Congress right now is kind of like, I think actually fewer pages than that, and basically just punts to the FTC on kind of figuring out what the problem is. So I think there's still a lot of conversation that can happen, and it happens at panels like this where we talk about what tracking is and what that means, and how it will work going forward. One concern that I have right now with the issue is that, at least with the current implementations, and I have hopes that this will evolve as we go forward, but right now it's kind of a very black and white, track me or don't track me, and I think part of the problem is that, well, okay, if you pop up a box that says, do you want to be tracked online? Well, okay, no is going to be the answer to pretty much everyone So the problem that arises is one of explaining, like, okay, well, so here's what tracking is, here's why it happens, here's how it helps pay for services that you're going to get for free, and is that a value proposition that is useful to you? Yes or no? Okay, well, now we know what we're doing. We know how we're going to move forward, and whether or not that's something that a person would be interested in engaging in. The other thing that I want to talk about, which hasn't really kind of come up at all here today, is kind of the flip side of privacy. So we're all talking a lot about consumer privacy, or what is it that the companies that collect information on you do with that information? You know, do they sell it? Do they advertise to you? So that's kind of one half. I think the other half that hasn't been mentioned yet today is actually government, the use of that information by government, specifically law enforcement. So underserved communities, the racial minorities, the poor are going to be keying onto this in actually a way that maybe it hasn't really happened yet, and that's a good thing. They're going to be suspicious of those groups are going to be suspicious of the benefits of broadband services when they find out that the government, and particularly law enforcement, are going to have access to the information that they move online in ways that they would not have anticipated based on their knowledge of what happens offline. So they probably know that police come to your door, they knock on your door. If they want to come in, they need a warrant. So that's something that, you know, they might not know how that happens or what happens, you know, or what the process behind it, but they know at least that's kind of the baseline that they need. That is not true when it comes to information stored online. And that fact is going to, we would be concerned, would we turn a lot of racial minorities or poor people off of wanting to use the services that can be really beneficial to them in the online world. The reason behind this is a law passed in 1986 called the Electronic Communications Privacy Act, which was actually originally passed because the Fourth Amendment doesn't apply to information that you hand over to other people. So whenever you go online and you say you use Microsoft MSN email, and you go to Microsoft and you say, hey, you know, store this email on your server. And Microsoft says, sure, happy to. You can get to it from anywhere. It's free. It's a great service, and so on and so forth. The problem is that as soon as I hand that email over to Microsoft, it's no longer protected by the Fourth Amendment because it's not in my house. It's not on my computer. So Congress saw this as a problem. In 1986, passed ECPA, the Electronic Communications Privacy Act. At the time, it was very forward-looking, but since then, it's been 26 years or whatever, and it's no longer really, it hasn't kept up with the times, and so a couple of the things that are particularly wrong with it. There's something called the 180-day rule, which is you put an email up on the web or in a web storage, and for 180 days it's protected by a warrant, but after that it's no longer protected by a warrant. The police or the law enforcement can get to it without needing a warrant. And so that doesn't really comport with our expectations anymore. It might have made sense in '86 when you didn't really, you know, hardware was expensive and you couldn't store things for a very long time online, and if you were left it there for 180 days, well, you would have abandoned it. So maybe that made sense then, but obviously that's not the case today. It's also a phenomenally complex rule. There are at least 8 different standards for how a single email might get treated depending upon where it is along the line. If it's on your computer, well, they definitely need a warrant. If it's less than 180 days old, if it's a draft, it's if you sent it, if you haven't read it, if you have read it, there's all these intricacies in the law that they don't make sense, and they really create a complex system where one isn't needed. In addition to which, in 1986, you couldn't possibly have predicted the geolocation revolution that these guys were talking about. Your cell phone is a geotagged device that, you know, everywhere you go, it knows where you are. Within a certain, you know, range. We can argue about how big that range is, but it's fairly accurate. And obviously in 1986 that was just not something that could have been predicted. So there's a movement going on now to amend the Electronic Communications Privacy Act to simplify it, to create a warrant standard for all data that you move online, and to include kind of a standard for access to geolocation data, which didn't exist before. Senator Leahy has introduced a comprehensive bill to amend ECPA, which we're very happy about, and we've been working with him for a very long time to make make that happen. And also, Senator Wyden and Representative Chaffetz in the House have introduced a bill that specifically targets geolocation in that question. So that's great. We're participating in a organization called the Digital Due Process Coalition, actually originally convened by CDT. It's a bipartisan group of companies, consumer groups, academics, law professors from both sides of the aisle who have all come together and really pushing for an amendment to ECPA, and so that's moving forward. And then the courts are actually starting to pick up on this issue as well. And we saw last year the Sixth Circuit ruled that basically information that you move online is still protected by the Fourth Amendment. Setting ECPA aside for a moment, that you do have a privacy interest in the information that you move online. So that's a really good thing to see as well. So we think that, as I said, starting off, this is a really important issue for everybody. It's obviously a really important issue for minorities who have to deal with issues of racial profiling or economic profiling day in and day out, and who will kind of take a look at that and say, hey, I'm not interested in the police having more access to what I do in my life. And so we're happy to see that Congress is getting on board. We're happy to see that the courts are getting on board. But that's definitely something that we're working hard on making happen.
So I just want to follow up quickly on one of the things we talked about.
Would that be Do Not Track?
It will be Do Not Track, actually. So this is something that CDT has been supportive of for a long time, that you use to be able to go into your browser and say, hey, I don't want to be tracked. So when I go to Washington Post and then go to ESPN, they can't, third parties who I don't know can't necessarily correlate that across sites. And it was, I think, about a year ago today when Chairman Leibowitz was testifying for the Senate Commerce Committee. He said, I want to see industry do not track. I want to see this happen. And we started to see the browsers do a pretty good job of rolling it out. And so Microsoft was, I think, the first in December to roll out a do not track instruction. But then, like you said, Ross, interested in kind of saying, well, we're not really sure what it means, so kind of in a holding pattern. So I wanted to get the group's thoughts on where is it going? Is it going to happen? Is there going to be some consensus around this? Is it going to die a slow, painful death? What happens? Eric.
So there certainly continues to be a robust discussion here in Washington about Do Not Track, and we feel at Microsoft that we've responded to calls for better user controls. We put tracking protection features into IE9, the latest version of our browser, to enable people to better control their privacy by blocking tracking by third-party sites. And essentially the way this works is that you can subscribe to a service that's put together by third parties, that they can make lists of sites that they believe are of concern, and you can say, I agree with this group's views about what sites would be of concern to me, and you subscribe to that, and then it would block based on that. Or you can customize the list on your own. You could add sites that you want to block, or and then it'll take care of that for you. And this feature also provides a mechanism for sites to determine whether users want to be protected from tracking, which we think is important, so that the sites know that a user has expressed that view. As any Do Not Track approach is considered, such as the Do Not Track bill that's been put forth by Senator Rockefeller, it's important to look at the work of the industry and other stakeholders in this area. There continues to be a lot of important discussion about what tracking even means, as was noted before. And until there's some consensus, it's hard to really know how to treat a Do Not Track request. IAB and other ad associations and consumer organizations like CDT are continuing to work hard on this issue, and we expect that there will be progress. But it's an evolving space and a continuing challenge.
Part of the challenge here, Justin, is also to make sure consumers have a good information-based understanding of the choices they're making. So if they decide they don't want to be tracked, there are some trade-offs there, obviously, because some services actually work well with some of the information that the consumers might be able to provide the provider. So, but I tend to think that if companies provide consumers with a default that basically lets them make the choice in many cases, that will be the right way to go. So, for example, now with our cell phones, we ship them with a label on the outside that says the location-based services that we control in the device, and we don't control all of them. As Bob said, a lot of them are done by the apps or the operating system, but the ones we do control, it's default set off, and it informs the consumer what it means to have it off, and if you want to turn it on, here's the kinds of things you can do, and obviously there's some risk, and we tell them that as well. So those are the kind of things I think that actually do give them a chance to think about it. What are the value for me as a consumer, and do I want it off or on or not?
All right, Deborah, thank you very much for your patience. Give us your thoughts.
Thank you. I'm still here. But I get to say good afternoon. I want to, first of all, thank Nicole and Ralph for including me on this panel to represent the older adult perspective and Project Goals perspective. It's one that isn't often included, so I appreciate that very much. I want to make 3 points today on this panel. First, why Project Goal cares about privacy. Second, what the project is doing about this concern. And third, what else needs to be done. And I'll try and do this quickly so we can get to your questions because the hour is getting late. First of all, Project Goal is a little over a year old now. Project Goal is the project to get older adults online, and what that means is it's working to promote broadband adoption among a community that is greatly behind the general population. I hesitate to talk about statistics with John Horgan in the room, but we have, about 67, 68% of the general population with broadband at home, and in the older adult population, it's about 36, 37%, so greatly behind the general population. And the benefits are huge. I don't think I have to tell this audience what older adults can do online, but it's a growing world for older adults in terms of what they can do and how much it means to an older individual to have broadband at home. So the value is great. So how does privacy come into play? Well, a little over a year ago, the FCC came out with their study about broadband adoption and use in America, which John Horgan was the author of. And what they found is one of the reasons for non-adoption was a concern about bad things happening online. So there's a general concern about safety, security, and privacy online. And for older adults, that's an even greater concern. So privacy does come into play for non-adopters, so for preventing those who aren't online to going online, and for those who are online, I think it prevents them from going in the full range of what they can do online. So privacy is a concern, and we need to do something about it. The challenges for older adults in terms of using the internet, we know what they are, demonstrating the value, bridging technology, digital literacy, as Nicole mentioned before. Those are all huge challenges, but safety, security, and privacy is another huge challenge for the older adult community. Regardless of the device, I know we've heard a lot about smartphones, but regardless of the device, privacy is going to be a major concern. So what is Project Goal doing to address this concern? Well, first of all, education is a primary focus for Project Goal. Project Goal just came out with a brochure which is You Can Stay Safe and Protect Your Privacy Online. We just distributed 700 copies of this at the conference that the National Association of Aging Agencies had last week, and we'll make this is also available on my website, theprojectgoal.org. And we'll be making this available to other aging organizations. So we offer advice for older adults on what they can do to stay safe online. So education, providing helpful information for older adults is number one. I'll talk about what some of these pointers are in just a minute. Also, telling consumers about the tools that they can use that industry provides is also another approach that we use to help older adults. But what are some of the challenges that we need to also work on going forward? Well, for example, one of the things I tell older adults is read the privacy policy when you go online. Well, we know for all of us, how many of us read privacy policies? Yeah, a few, but we're the most aware of audiences, and we don't even look at our privacy policies. So most of us don't read them. Older adults are really the only ones who look at the inserts in their utility bills. They do read things, but the likelihood of them looking at a privacy policy and going through those 8 pages and understanding it, we need to simplify that and make it readable for older adults. So that's number one. We need transparency. We need to be able to tell them what's going on with their information, and we need to give them some choice and some control over what happens with that information. Another thing is we really do want to get them online. We want them to be using the internet. And when I get a group of older adults together and talk to them about going online, even those who are online, half of them don't shop online. And the reason why is because they're fearful. They're fearful of what's going to happen to their information. So these are internet users who are afraid. And I know we talked about we already have great protections for our credit card information. They still don't want to put that information online because they're afraid of what will happen. So we need to educate, we need to provide the right tools, we need to make this simple, and we also need to make this real. So we don't want to oversell the fear factor. We don't want to give them a sense that it's scary out there. We want to give them the right information and help them as much as we can. So we need to give them the right confidence that they can stay safe and they can keep their information private online. So thank you.
Thanks. Okay, so we're kind of running over, and so I'm glad I snuck in a couple of my questions when I did. But if anyone from the audience has questions, yes, Cecilia.
Hi, I'm Cecilia Kong with the Washington Post. I have a question for, Link, Eric, and Bob, and maybe Ross, you can answer this as well. Can you just be sort of specific? I think a lot of this is sort of hypothetical. What does law enforcement ask of you in terms of what your users are doing, both from the carrier side, cloud computing, from Microsoft, your members that do cool things, as you say, Ross? Like, what do they ask for information that could target a particular community, and what are you compelled to give, and what do you give? What information?
The law enforcement asks for data in subpoenas that they issue to us, just as they've done for since the beginning of time. And those requests come in and they are processed, and we comply with our legal obligations for whatever they ask for that we have in our possession that's identified in the subpoena.
Let me explain. I think the point that Ross was addressing is that the Electronic Communications Privacy Act, which was passed in 1986, was based on an assumption by Congress that it was unclear to what extent communications that were held by third parties would be protected by the Fourth Amendment, the contents of those communications. And there were certain assumptions that were made at the time that if something were held for an extended period of time by a third party, then the protections should drop. It should be something like a business record. By way of example, when I started working in this space, I was at the AG's office in New York before Justin was there. At that point, pretty much all email went through AOL, and AOL's policy for retention was that if you read an email, they would keep it for 3 days, and if it was unread, they would keep it for 30 days. And then after that, it was gone. So the idea that messages would sit around for more than 180 days was actually somewhat theoretical. And so the idea that a message that was sitting around for that long would be treated by a lower standard under the law was again somewhat theoretical. Fast forward to now, the things that we keep online, the things that we keep for the longest periods of time, the pictures, the email messages, the documents that we store in cloud computing services, are the things that we care about the most. And so what's happened is that the technology has evolved. It was a good law, and it was well thought out at the time, but the technology has evolved to the point where some of the assumptions that were built into the law, in our view, no longer make sense. And we want to make sure that the law matches up with what people's reasonable expectations of privacy are. So as is also true of CCIA and of Google and AT&T. We're members of the Digital Due Process Coalition, which was organized by the Center for Democracy and Technology, which is calling for some changes in the law. And what we're trying to do is we're trying to strike the right balance between the reasonable expectations of privacy of our consumers and users and the needs of law enforcement. And we just think that the law has not kept pace with technology and requires some revisiting.
Yeah, she was trying to get a sense of the scope and how often do they get subpoenaed. So, I obviously I can't speak for any of the rest guys up here, but I do know that, and Eric, Microsoft might do this too, but Google has a webpage that you can go to that tells you, doesn't tell you what they're asking for, but it tells you how many requests they get from law enforcement around the world. So not just the U.S., but in other countries as well. And it's for my, I'm not speaking for anybody else but me, but it's a staggeringly large number.
The statute sets out a framework, though, that requires, a search warrant for messages that are kept for a short period of time, and then it drops the standard to allow for the use of a subpoena or a court order for messages that have been kept for a longer period of time. The Department of Justice has maintained the view that if a message is open, that it falls into this lower standard of protection. The courts have split, and I think the key point here is that this feeds into the perception that people have around the world that we have a complex set of privacy rules in this country that don't match up with. So not only do we have concerns that it doesn't necessarily match up with people's reasonable expectations in this country, it feeds into the perception that if you were to do business with a cloud computing company that's based in the United States, that there would be too easy access to your information by law enforcement. And so we want to make sure that we are raising the standard in the law so it comports with people's reasonable expectations, and it also allows us to push back against other countries' requirements that, for instance, might put us in a position where there's a data retention requirement in one country that conflicts with a data destruction requirement in another. We need to make sure, I think, as the point was raised before, that we have laws that are interoperable, that are compatible. Even if we can't achieve harmonization, we want to make sure that we have laws that don't put us in a position where we are breaking one country's law in order to violate another country's law. That we are violating one country's law in order to comply with another country's.
One amusing side effect of the DOJ's approach that if you've read an email, it falls to the lower standard is that under their reasoning, every single spam email that you never read and went straight into your inbox has a greater protection under the law than the letter from your mom that you got yesterday and read. So, anyway.
Let's take one more question.
Good afternoon, Crystal Hyde, Politic 365. A quick question is, with this data profiling issue, is there a way at this point to be sure that that practice won't produce the same consequences as, say, racial profiling? And along those lines, when we talk about educating consumers, beyond just educating them about a privacy policy, is there a way to educate them about the potential harms? Because that could be an incentive to somebody to alter their behavior online.
So one of the things that was mentioned earlier by Eric was the participation with the Better Business Bureau in an ICON program that AT&T has participated in. And pursuant to that program, and when we're participating as an advertising company, that's our yellowpages.com. Pursuant to that program, any ad that is served from a member of that corporation is going to have a little box in the corner, and that box, when it gets clicked on, gives you the ability to opt out of advertising, but it also gives you the ability to see what data is collected. And generally, what the advertising companies do is they don't want to collect data in too many different buckets. They're going to generalize what that data collection is and say, our profile of you says the following: you have interests in cars. It's not going to necessarily say that you have an interest in a Lexus or a specific type of car, because what matters to them is if you're car shopping, they want to be able to deliver an ad. But they have a process through the ICON program that allows you to go in and see the different categories of interest that that the ad companies who are behaviorally monitoring your behavior are assigning to you, and it gives you a process to edit that. If you think that they think you're interested in something that you're not interested in, they'll give you a process to be able to go in there and edit. The idea behind the ICON was to put that type of information to make it transparent to the end user, to make it accessible by the end user, and to give the end user some kind of control over the perception that online companies have for them. And I think that and especially with the advertising companies, I think they're trying to make progress to put those tools in the consumer's hands to, in my view, avoid ending up with racial profiling or something along those lines. But at the end of everything, we have to educate customers more. I'll tell you, when I became the CPO, I was amazed to find all the different tools that are actually available in different browsers that you utilize that help you to monitor who can track data for you. And there's an amazing amount of tools out there, but the only way we're ever going to get those in people's hands, like my mother, is through some form of education process, because my mom is a little challenged technologically, as probably a lot of moms in this room are, or moms of us in this room are. She just, it's a little bit of a challenge for her, but she's interested, and I've kind of introduced her to some of these things, and I think, I know she goes off and talks to her friends about some of the different add-ons that are available in one of the browsers that she utilizes, because she found it very fascinating that it would identify for her all of the different companies that have script running on a particular web page. She was absolutely fascinated by that, and then wanted to figure out what all these companies were and why they were monitoring behavior. But I think that the education process is really the most important thing that we can do to allow people to understand the tools that they have and to try and make this much more of a customer control environment.
So I'm going to give my good friend Nicole a challenge here. One of the things that, and Bob mentioned this, we've been trying to do in Verizon and a lot of companies that have a lot of different services they offer consumers in the privacy space are trying to do is make sure their privacy policies are consolidated, understandable, as easily readable as possible, and tell you exactly what kinds of choices you have as a consumer, what kind of information is gathered, when, and for what purpose. And I think a nice thing that Joint Center and groups like that can do, because as we all know, that's a lot of information. It's very likely that most consumers will probably never take the time to read it all. But the Joint Center can challenge companies by actually doing their own assessment. What they think of the privacy policies that companies have, are they readable, understandable, what do they provide, where do they think there are some faults. That's a useful thing for groups like the Joint Center to do, especially representing the groups that they represent. It can help a lot for consumers, and it challenges companies, which makes them do a better job. So that's all, to me, a very positive way to look at things.
I'm sorry, one last thing I would add. Do you want?
I was going to add one last thing.
We all want to add one last thing.
One last thing.
Okay, Deborah first.
Well, I just wanted to second, I guess, what both folks said there, and say I would be happy to work with you, Nicole, for the senior perspective on that, because I think we have to get it simple. We have to break it down, because I think there is a lot out there. We just have to, number one, make sure that folks know about it, and then make it simple for them to use, because it is very complicated. And I also just want to mention that this is out on the table if folks want to pick it up, the brochure there. So thanks.
Yeah, and I just to your second question about harms, I think. It's an interesting question, but just to reframe the language a little bit, I don't think we want to tell people about harms, because especially when it comes to privacy, harms are very personal. What one person might consider a harm, another person might be 100% comfortable with. So it's very difficult to tell someone this is the harm when it comes to privacy online. I think what was important is the transparency of what is happening. So here's what we collect, here's what we do with it, here's where it goes, here's when we delete it. You can decide what the harm is to you. If you perceive that as a harm, then don't use this service. If you don't perceive that as a harm, welcome. But not to tell you that this is a harm, but this is what we're doing. Do you think that's a harm? Is the more important question.
One last thing I would add, and then we absolutely have to. Oh, sorry, Eric. You can add.
I just wanted to, obviously there's a distinction between discriminatory practices, which should be pushed back against, and then the idea of targeting an ad to an audience that's relevant to. And we participate in the Ad Choices initiative that Bob was talking about. I think the key point in regards to the line, though, is the matrix that Link referenced before, the idea that you have to think about the sensitivity of the information and then also how it's going to be used, and those two factors are very important. And we want to make sure that within the realm of what's legal and should be permitted, that there's an opportunity to freely experiment with different business models, so that consumers are free to choose whether or not they want to pay for a service or accept a substitute arrangement where they allow data to be used in exchange for receiving a product or service. It's not right or wrong, in my view, to pursue either model. The key is that our companies are transparent about what we do with the information and that consumers have meaningful choices. It's not our business model, for example, to target advertisements based on the contents of your email. Some companies do that, and if consumers understand the trade-offs and they make informed decisions about the privacy practices of the companies with which they do business, then that's fine. But the key is that we have to make sure that people have the information, that the information is understandable to them, and that they have meaningful opportunities to make choice. And if that's what happens, then we think the market will function correctly.
And the very, very last thing I want to say, and it's going to be a link, so there actually are protections under the law for some harmful uses of your data. So around like credit and employment, there is the Fair Credit Reporting Act. But those are kind of, if ECPA passed in 1986 is outdated, the Fair Credit Reporting Act passed in 1970, and data brokers have kind of found a way to evade a lot of those protections. And there's actually a really great story in the Washington Post from last Sunday, I think, talking about how data brokers use information from check cashing services that focus really more on disadvantaged groups that kind of get around some of the protections from the Fair Credit Reporting Act. So I would recommend that article to all of y'all. With that, I'll turn it back to Nicole.
Okay. Let's give this panel a round of applause.